The Honourable Member, Chris Farfui.
Talohane.
Yeah, okay.
Thank you very much, Mr Chair, for the chance to take a very quick call on Part 5, because I don't want to delay the proceedings of the House too much. That would be unfortunate. But just looking at Part 5, it does refer to the appointment of lawyers to represent children in proceedings. And I thought that it would be a shame to have a part in this bill where the Labor Party doesn't refer to the regulatory impact statement, because it has been a very important document in our argument, to prove our argument that this bill is not necessarily about making life easier for Kiwi families, but is actually around the cutting of costs. And on page 13 quite helpfully helps us illustrate that, because it does talk about the targeted use of lawyers for children. And in a very kind of bureaucratic way, I don't mean to say that to the bureaucrats to any detriment, but it does say about the way that we change the way court appoints lawyers for children. Moving along from the description of what they're trying to do and going straight to the financial implications, because that's what this is all really about, for the government at least, it says the estimated cost savings for changing the way that the court appoints lawyers for our children is $12.4 million per year based on 2010-2011 expenditure. So there you have it, another big whack of cash that the government has saved. So I guess if you think about the motivation for the government and for the minister, it's done its job, because $12.4 million has been saved by cutting the access to children for legal representation. Now, Mr Chair, we've heard from the Christchurch family court judges already in the previous part, but I did want to just take another part of their submission to the Select Committee, because I think it's very telling what these judges are saying about the changes that are contained in this bill. Now, I'm quoting from their submission now, and where they say, although the bill contains reasonable powers for a court for a judge to appoint a lawyer to represent children, our concern is that the control of their role and remuneration is transferred from the family court to the Legal Services Agency. We foresee they will be confined by regulations which are not part of this bill, but which would be enabled to it. And I just want to repeat what they say about the role of children's lawyers in family court disputes. They say that the lawyers are the machinery which enable us to make safe and appropriate decisions for children. They are the eyes and the ears of the court. Without full participation, when needed, of the child's lawyers, judges will not be confident they can make the decisions which we keep safe. Now, one of the more crass things that I've heard from the Minister this night is an attack on lawyers about this being some kind of gravy train for them. Now, when this piece of legislation was introduced, lawyers in my patch and Porirua were very, very fast to come to me and say, we have grave concerns about what's in this piece of legislation. Not because they thought their incomes were going to be affected, but they knew, Mr Chair, that the changes within this bill would adversely affect the people that the law is meant to help, Kiwi families. They knew that the fee for the Family Dispute Resolution Service of $900 would be restrictive and would stop people accessing justice at one of the most vulnerable times of their lives. They knew that restricting the situations where children could have lawyers appointed for them would also take away the children's voice in these disputes. And I did just want to, if I can find it in time, take a quote from a story that was in the media when this bill was first introduced. And it's a very quick quote from Professor Mark Hennigan from the Otago University, where he said, around reducing the access to lawyers for children, he said, if you take their representation out, then we doom them not to be heard. Then we doom them not to be heard. Now, I think that is a very telling statement from someone in the legal profession who has got a lot of credibility about what this government is doing for the voice of children in the legal process.
Be seen and not heard.
They know that children won't necessarily have a voice in this place, won't necessarily turn up to make a submission to the Select Committee, so they're quite happy to take away their legal representation. to save, per year, $12.4 million to meet the requirements of the government's motivation around this piece of legislation. And I say to that government, shame on them. If they're quite happy to take away the voice of the children, Mr Chair.
The Honourable Member, Chris Farfoi.
I said it was going to be short. But if they're quite happy to take away the voice of children in the family court proceedings, then I say they should front up to the people, to the Law Society, to those people who have submitted against this bill, and say why they're quite happy to do that. Say why they're quite happy to take away their representation and then doom the children not to be heard. Because, Mr Chair, again, I want to stress this point because the Minister has made this point a number of times when she's made contributions to this debate. She says that this bill is about the care and protection of children. Well, I'm not buying that, and a lot of people who have submitted to the Select Committee aren't buying that. This bill is not about kids, it is about cutting costs. It is about cutting costs, and $12.4 million has been cut from the bill to make sure that there is legal representation for the kids by making these changes. So, Mr Chair, we're very concerned about the access to justice for those kids and their families, because this government seems to think it's okay to take money away from low-income families, as the regulatory impact statement has said, who need to access justice, but is quite happy to give it to big business when it suits them, with the likes of Rio Tinto, with the likes of Sky City, and also hock off our state-owned assets. It's all fun and games when there's millions concerned, and it's bringing the money in. But for the little people out there who need some help when they need in tough times, this government doesn't care about them. They're quite happy to penny pinch when it's people who are vulnerable in difficult times, going through separations. But when it's big business, it's quite happy to write out the big cheques. So, Mr Chair, that's the kind of government we have right now. That's the kind of government we have right now, when it will quite happily nip and tuck at people who are in vulnerable situations, who are low incomes. Sorry, I'll take that back. People who are in vulnerable situations and family court disputes. But when it comes to big business, when they come knocking, they'll quite happily write out the cheques. Mr Tauhenere probably isn't happy about this privately. He's not happy about it privately, but he's going to have to go along with the flow, because he knows the people that he represents as a list MP in West Auckland will come to him and say, Toe, this is not on.
Order.
This is not on.
Order.
Oh, just being factual.
No.
They know.
Order. The member must use the Honourable Member's full name.
Mr Tauhenere will know that he'll have people coming to his office saying, Toe, why can't my kids access legal representation in this situation? And Toe will have to front up and say, because we're cutting costs. And they will say, but we read the paper and Judith Collins said this is about caring for kids. Well, the truth of the matter is that it's not. It's about cutting costs, not caring for Kiwi families. And I think that's borne out by the fact that this government seems to care more about corporates than it does about Kiwis, Mr Chair. Thank you very much.
Right. The question is that Part 5 stand part, but before we do that, we have some amendments to vote on. And the first amendment is the Minister's amendment, set out on Part 5, or amendments to Part 5 set out on SOP number 349. Those in favour, please say aye. To the contrary, no. The ayes have it. Party votes called for. The whip has asked for a party vote. The clerk will please conduct one. Thank you.
New Zealand National.
59 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party.
14 opposed.
New Zealand First.
7 votes opposed.
Māori Party.
2 votes opposed.
Mana.
1 vote opposed.
ACT New Zealand.
1 vote in favour.
United Future.
1 in favour.
Brendan Horan.
1 vote opposed.
Any other votes?
Thank you. Honourable members, the ayes are 61, the noes are 59. The amendments are agreed to. The question now is that Part 5 as amended stand part. Those in favour will please say aye. Those opposed will say no. The ayes have it. Party vote has been called for. The opposition whip has called for a party vote. We will have one. Thank you.
New Zealand National.
59 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party.
14 votes opposed.
New Zealand First.
7 votes opposed.
Māori Party.
2 votes opposed.
Mana.
1 vote opposed.
Act New Zealand.
1 in favour.
United Future.
1 in favour.
Brendan Horan.
1 opposed.
Honourable members, the ayes are 61, the noes are 59. Part 5, as amended, will stand part. Honourable members, we now come to clauses 1 and 2. The question is that clause 1 stand part.
Mr Chairman.
I call the honourable member Andrew Little.
Well, Mr Chairman, I think this debate and this day will go down as a day of great disappointment